Welcome to Legal Lines. My name is Tom O'Shea, the host of this program, brought to you by the York County Bar Foundation. My guest for today's show is attorney Suzanne Griest from the law firm of Griest, Himes, Herald, and Reynosa. Welcome, Suzanne.
Hi.
And our topic today is divorce law. And Suzanne is one of the attorneys in York who practices in the family law field and handles many divorce cases, I would say.
Yes.
And let's start out with a general topic of what people refer to as no-fault divorce.
Well, in Pennsylvania, there are two kinds, no fault and fault, and they are sort of what they imply. That with a no-fault divorce, there's no assignment of blame or guilt for the breakup in the marriage. And with a fault divorce, the person who's filing is in essence saying they're the innocent and injured spouse, and the other person is the bad guy or girl, if you will. And there are 6 legal grounds or reasons that you can file for a fault divorce, and those are things like adultery, bigamy, desertion, long-term jail sentence, long-term mental institutionalization, and then there's what I call the catch-all. And that seems to be the most popular one besides adultery, which is something called indignities, which is...
Now, what's the legal definition of an indignity?
Well, that's any kind of conduct that renders the other spouse's life intolerable and burdensome.
That is the legal definition.
Yes, and I usually tell my clients that that's something like lying, cheating, swearing, being abusive to any kind of conduct that just makes your life miserable.
Okay. Now, as a practical matter, prior to 1980, the only way to get a divorce in Pennsylvania was by proving one of those 6 grounds for divorce.
Correct.
But since 1980, there is a no-fault divorce law. And as a practical matter, how many fault divorces go through the system now?
Boy, if I had to guess, I'd say less than 5%. I've been practicing in this area. I think I'm starting my 33rd year, and I have yet to get a fault divorce. That doesn't mean I haven't filed for them. Doesn't mean I haven't gone to the actual courthouse steps, if you will. But generally speaking, when the economic issues are resolved, the divorce is filed as a no fault, because it's easier and cheaper.
It's easier for the parties to go through. It's cheaper for them. So even in cases where there is fault, and maybe even terrible fault, as a general rule, the parties opt for the no-fault process.
Right. I think maybe the only time I could see a fault divorce happening is sometimes people for religious reasons they can't consent to a divorce, or they can't. So they just sort of sit back and do nothing and allow it to go through, either as one kind of the no fault or a fault divorce.
One thing I'd like to point out as well is and I believe many clients believe that if you get a fault divorce, you wind up with some type of better economic resolution of the case than a no-fault divorce. Is there any truth to that?
Absolutely not. Marital misconduct plays no part in how assets are divided.
So there's no economic benefit to go through the fault divorce process?
Correct.
In fact, it's an economic detriment because you're going to be spending more money on legal fees and court costs.
Right, because you end up having to go through the divorce master's office and that process, and that's very expensive.
Okay, now let's talk about no fault. You mentioned there are 2 types of no fault.
Right. There's the consensual divorce, and there's the non-consensual divorce, if that's a word. Basically what happens is someone initiates a divorce action under the no-fault statute, and once the other party receives the papers in their hands, that starts the clock running. And there's a minimum waiting period of 90 days. At the expiration of the 90 days, it is possible that the parties could consent to a divorce, and the divorce could be finalized within 2 to 3 weeks after that. Now, it requires consent. And that means that one party has to sign a document called an affidavit of consent. And it says something like, I acknowledge the divorce complaint was filed on the particular date. I agree that 90 days has elapsed. I agree that the marriage is irretrievably broken. And those are the legal words for the no-fault divorce. I consent to the divorce. And then we get into what I call the kicker paragraph, which is if there are economic claims, if you sign that consent, you are forever waiving your right to make economic claims. So in a lot of cases where people have things to divide, like houses and cars and pensions and things like that, what they try to do in the 90-day period is they try to come to an agreement about that in an ideal world.
So the 90 days is the minimum amount of time
Right.
that people have to wait.
Right, nothing magical happens at the end of the 90-day period. Life just goes on until an agreement is reached either between the parties, through counsel, through some other process, or through the divorce master's
Now, when you're talking
office.
about an agreement, you're talking about some type of agreement with the economics of the
Right.
case. And we'll talk a little bit more about the economics of divorce law in a few minutes. But if there's a 90-day waiting period, the 90 days comes and goes, nothing's going to happen until both parties consent.
Correct.
And typically, it's not a good idea to consent until you reach some type of economic resolution.
Or protected your right to deal with it later after the divorce is granted.
Okay.
Yes.
So, with respect to the waiting period, what happens if one person consents and the other does not?
Nothing.
Nothing. So the 90 days comes and goes, and one person isn't willing to consent, they remain legally married.
Correct.
Now, is there a time period where that changes?
Yes. If parties are separated for a period of 2 years, then the moving party, the one who wants the divorce, can file an affidavit saying that they are separated for 2 years, that the marriage is irretrievably broken, and they can serve that on the other party. If they do nothing, operative word is nothing, they can get a divorce without the other party's consent. Now, the other party, again, if they want to make economic claims, usually they're going to file what's called a counter affidavit, and they're going to say, I want to raise certain economic claims, and the divorce will not happen, but it permits that moving party to sort of push them through the system.
Okay, so the 90-day no-fault divorce, as I understand it, is based upon the filing date.
Correct.
Or actually the service date.
Mm-hmm.
So somebody files for a divorce, one spouse files, the other person is served, the 90-day waiting period begins.
Correct.
And then both people have to agree, after the 90 days is up, to consent to the divorce to move the case forward to the divorce.
Correct.
What if the person who files says, I filed for the divorce, I asked the court for the divorce, but now I'm not going to consent? Are they obligated to consent?
No,
No, so they can change their mind.
they could.
And that, I think the intent of the law is what is called a cooling off period.
Yeah,
So just because somebody filed doesn't mean they have to consent.
that's correct. There are some cases that kind of address that because basically a lot of attorneys will argue that by filing the divorce and by saying the marriage is irretrievably broken, you have an obligation to move forward. And in certain circumstances, you do. If you make certain claims, you have an obligation to actively pursue your divorce.
Okay? But the court cannot make you consent.
Right.
Even if you're the filing party who originally asked.
That's correct.
Now, if both parties do consent and they have reached an agreement on their economic issues, is there a need for them to go to any type of court proceeding to finalize the divorce?
No, no. They could sign the paperwork in their attorney's office or wherever, and as long as it's submitted to the court with the appropriate paperwork, the court will grant the divorce.
So how do they know that the divorce is granted?
Well, there's the person who filed for the divorce will get an actual decree.
The divorce decree.
Yes. The person who did not file for the divorce will get a piece of paper from the prothonotari's office that says a decree has been entered against you, and that's the date the divorce is final.
So people typically find out several days after they're divorced that the court granted the divorce.
Correct.
But they don't have to go to any type of court proceeding.
That's correct.
Now, with the 2 years, the starting date is the date of separation.
Yes, and that gets sometimes a little problematic, determining what is the date of separation, because a lot of people continue to live together in the same house, and you can be considered living separate and apart in the same house. When we normally think of it, we think of like jets, and they're often different households. But to live separate and apart in the same house, the definition is that you're not sleeping together, you're not doing anything together as husband and wife, you're coexisting in the same space like roommates, and, big and, someone has said to the other party, I'm done, I want to be divorced, or something along those lines.
So there's notice to the other person
Correct.
of the intent to be separated.
Right.
Now, if there is a 2-year waiting period and somebody says, I've been separated for the 2 years, I want to proceed, the consent of the other person isn't needed. Is that correct?
That's correct.
But how do they get the court then to grant the divorce without the consent of the other party?
They have to file what's called a 3301D affidavit, which is a 2-year affidavit. They file an official affidavit with the court that says, I have been separated for 2 years. And it says that the marriage is irretrievably broken and that they're asking the court to grant the divorce. That is served on the other party with a counter affidavit, and they can choose to respond by checking boxes on the counter affidavit, or they can do nothing.
So the counter affidavit is actually a form
Yes.
that the moving party has to give to the other side to give them the opportunity to respond.
Correct.
And they can contest whether or not the marriage is irretrievably broken or the 2 years isn't up.
Yes. They can check a box that says, I do not agree that we've been separated 2 years, or I do not agree that the marriage is irretrievably broken.
Okay. Now, if they do nothing, then the court can grant the divorce based upon the original affidavit.
That's correct.
What happens if they check one of those boxes and say, the 2 years isn't up?
Well, then the moving party has, I think, a couple choices. One choice is to appoint a divorce master to determine whether, A, they've been separated 2 years or not, if that's in dispute, B, whether the marriage is irretrievably broken, if that's in dispute, or there is another option to seek what's called a bifurcation, but that's a little bit more complex.
I realize it's complex and we're running out of time in the first half of this program, but basically bifurcation, as I understand it, means the court will grant the divorce before addressing the economic issues.
Right. You treat the divorce as being two parts. One is the bonds of matrimony and one is the economic
And we're
claims.
going to talk about the economic issues in the second part of the program. My guest today is Suzanne Griest, and this is Legal Lines. We'll be right back. Welcome back to Legal Lines. My name is Tom O'Shea, and my guest today is attorney Suzanne Griest. Our topic is divorce law. And in the first part of the program, we talked about the process of fault divorce and no-fault divorce. But now we're going to switch focus to the economic issues of divorce. Okay. So welcome back, Suzanne. And with respect to the economic claims in divorce, I think the primary claim is what we call equitable distribution. So I'm going to ask you to define equitable distribution.
Equitable distribution is the process of dividing your marital assets. And by definition, marital assets are anything that came into existence from the date you got married until the date you separate. Doesn't matter whether it's in your name, your husband's name, or joint name. If it came in during that window of time, it's a marital asset. Now, there are a couple exceptions to that general rule. Exception number one is if you had property before you got married. If you had a bank account that had $10,000 in it, and for some reason you still have it, and it's in your name, and it appreciated in value to $11,000. That $10,000 is your money. Your husband cannot take it from you, but the $1,000 that it appreciated in value would be in the marital pot along with all the other assets. And unless you took the $10,000 and you commingled it. You said, on the day after you got married, I love you, we're going to be married forever, what's mine is yours and what's yours is mine, and all you did was go down to the bank and put your spouse's name on that account and made it joint. When you did that, you made a gift to the marital unit, and it's in with everything else. Second exception is a gift. If your mother gave you $10,000 check, and again, you put it into an account in your name alone, it's not a marital asset except for the appreciation and value. But if you put it into the joint account or bought a car in joint name, it is now a marital asset. And the third exception is inheritance. If you inherited money, again, same rules apply. The fourth one is if anything you acquire from the date of separation until the divorce is final. So we talked about some divorces that languish on for a long time. If you begin to save money post-separation, that's your own separate property.
Okay, so that would be the non-marital property, but the marital property is subject to the division, the equitable distribution.
Correct. Mm-hmm.
Okay, so once we determine what is the marital property, what is the next step?
To determine what the value of the marital property is. And to determine the value of the marital property, generally speaking, assets are going to be valued whenever they are distributed, which means whenever a decision is made about who's getting what.
Either by agreement of the parties or by the court deciding how to divide it.
Correct. However, in your county, we value some assets at the date of separation. So, we value vehicles generally at the date of separation. And we value them at the NADA Blue Book value. We value retirement plans let me explain that. If you participate in a 401k plan, we're going to take the value in your 401k plan at the date of separation. But again, if your divorce case languishes for a long time, if you continue to put money in that 401k plan, those contributions are not marital, but the interest and the market fluctuation on the date of separation is going to be marital.
And that could make things complicated if someone has a 401k that's invested in several different types of funds.
Correct.
So we define the marital property on the date of separation, but we value it close to the date that it's to be divided.
Correct.
A simple example, I believe, would be a house. Okay, the parties separate. They separate. No one moves the divorce for 2-3 years. The house at the time of the separation was worth $200,000. 3 years later, the real estate market takes off again, and it's worth, let's say, $230,000. They're going to divide the $230,000 value of the house, not the original $200,000, because that was the value at the time of the separation.
That's correct. And if it had a mortgage on it, we're going to take the mortgage balance at the time we distribute it as well.
Even though one person was in the house paying the mortgage?
Yes. Yes.
Well, how's that fair?
Well, usually that's adjusted somewhere else, or it depends on whether there are support obligations. There may be claims for fair rental value. There's all kinds of ways, but generally speaking, that's what happens.
So now we're going through the process of, first we define what the marital property is. Now we value it. And there could be some issues like with appreciation of value. Some assets, I believe, would be harder to value than others. Retirement assets might be one of them.
Right.
If there's a family-owned business.
Right.
And sometimes it's necessary to get accountants and experts involved in the evaluation process. Am I correct?
That is correct. Personal property, in an attorney's world, we don't like to generally deal with personal property, but clients, it's very important to clients. And those things are valued at what they would bring at a public auction or a yard sale.
So when you're talking about personal property, it's mainly the furniture?
Yeah, household goods.
Household goods,
Yeah.
furniture. And in the divorce lawyer's world, they're not worth that much money, but the client might think it's important to have the living room furniture that they're used to or whatever.
Right.
But the court's going to value it at a very low value.
That's correct.
All right? Now, once the assets are valued, they determine what's marital property, there's values assigned to it, what's the next step?
The third part is then determining how it's divided between the parties. And the divorce code tells us that there are 11 factors that we are to consider, or the court is to consider, on what is fair and just, depending on the individual facts and circumstances of those two people.
So it's not automatically a 50-50 split.
Absolutely not. And you shouldn't even presume or assume that it's a 50-50 split.
So how does one determine what is equitable in the distribution if it's not to be 50-50?
Well, you look at things like the age of the parties, the health of the parties, how long they were married, the number of marriage, their respective incomes and earning capacities, what if they have minor children, what their custodial arrangement is, the standard of living that they operated under, whether one party was a homemaker, did one party work while the other party went to school to obtain an advanced degree or some kind of professional degree, what kind of assets they have in their own right. Remember, let's go back to the non-marital property. Did they come into the marriage with a lot of assets that they still have out there in their own name, or that they inherited that are out there? We're going to look at that kind of thing to see how that weighs in on how we divide the marital stuff. Another one is what I call contribution and dissipation. And that looks like, suppose someone inherited $100,000 6 months before they separated, and the other spouse said, hey, don't you think we ought to pay the mortgage off? And they took the $100,000 and they paid the mortgage off on the house, and then that spouse says, I'm out of here. You know, in that particular situation, we might say, the stupid spouse who paid off the mortgage, we might give him or her more of the equity in that particular asset because it wouldn't be fair to do it the other way. But if that happened in year one of a 40-year marriage, it's probably not going to mean a whole lot. So that's contribution. Dissipation is a spouse who might have a drug and alcohol addiction. They've been in rehab many times. They've ran up the credit cards to finance their habit, or they borrowed against the house, and that other spouse, we might give them more because of the conduct of the other.
How is it determined how much more to give that spouse?
Well, I don't know that there's any real answer to that. It's a balancing of the equities and what the particular assets are in any given case. They're going to look at expenses and the standard of living, that kind of thing.
So there's no formula
No,
to decide what is fair and equitable.
that's correct.
It's purely a court would look at these factors to determine what the court believes is equitable.
Right, they're going to look at them on a balancing test and see if the factors balance in favor of one person or another to determine what the distribution should be and how much.
So it could be a distribution of, let's say, 60-40 instead of 50-50, 55-45, 75-25. And the goal is to keep people out of court and reach a settlement. So how do people know whether or not they're reaching a fair settlement?
Well, I think they have to rely in some part on the experience of their counsel, and there's some case law that would help to determine how other courts have looked at that.
So basically what you're saying is that these people should get advice from a lawyer who's seen various situations many times, who would get a feel as to what the court may think is equitable.
Yes.
All right. Now, we only have a few minutes left, but there are other economic claims other than the division of the property.
Correct.
Does Pennsylvania have alimony?
Yes.
And alimony is payments by one spouse to the other spouse to help support the financially dependent spouse.
Correct.
Is there a formula for alimony?
No, they've tried to do that, but there is no formula.
Okay. Now, I believe there is a formula for spousal support.
Yes.
Can you describe the difference between spousal support and alimony in a little less than a minute?
Okay. With spousal support, you don't have to be divorced or have a divorce action. You can simply separate. With alimony, there has to be a divorce filed, and alimony is simply a payment made after the divorce is final.
Okay. So alimony is after the divorce. Spousal support is before the divorce.
Right.
Spousal support, there is a mathematical formula.
Yes. Generally speaking, if there are no children, it's 40% of the difference in the net incomes of the parties. If there are children, 30% after you determine the child support obligation.
And with respect to the alimony, it also takes into account how the assets are divided.
Correct. Actually, there's a presumption not to give alimony if you can give more in assets. Yes.
All right. So alimony is sort of the second thought when it comes to the total economic division.
Right, and there are 17 factors to look at. And please understand that I never said when we divide assets, marital misconduct. A lot of people like to think that because one spouse is at fault that they should get more.
I'm going to have to cut you off here because we're out of time. My guest today was Suzanne Griest. This is Legal Lines. Thank you for watching.